All right, I'm going to give you a brief introduction on American court systems and what's referred to as ADR, or Alternative Dispute Resolution. It's important for businesses and business people to understand the court system because, number one, you don't want to be in there. You want to avoid that if at all possible because it's very costly, time-consuming, emotionally draining, etc. There are ways to avoid ending up in court if you're a smart business person, and I'm going to tell you some of those ways to do that. But understand the court systems on the state and federal level are essentially a parallel system. There'll be a court of, let's say, called general jurisdiction where most of the cases will go. You would have one right to appeal, normally to the Court of Appeals, for example, in the state of Washington. On the federal level, we call that the circuit courts. And then finally, there's the Supreme Court, whether it's the U.S. Supreme Court or the state Supreme Court. You don't have a right to go there except for very unusual cases where that court has original jurisdiction by statute or by constitutional provision. But I think it's important to understand you don't have a right to go to the Supreme Court. That's the Supreme Court, whether it's state or federal, exercises discretion as to what type of cases they take. Typical civil case will begin with a service of a summons and complaint or filing, depending on whether you are a state or federal case. When you get served with a summons and complaint, it's important to understand that a summons is simply a 1 or 2 page piece of paper telling you to wake up, you're being sued. Attached is the complaint. And the complaint sets forth a number of things. It'll talk about jurisdiction, which is the authority of the court over this case, and you, or the subject matter. I'll talk about that momentarily. And it'll set forth who the parties are and then the claims, and then whatever remedy the plaintiff is seeking. And it could be, again, monetary damages if that's at issue, or some sort of equitable remedy. Important to understand the terminology in a civil case. As part of the trial process, there are a number of motions that can be filed, pre-trial, post-trial. There's a thing called discovery process in a civil case, as well as criminal case, I should add. And discovery is, as the term would suggest, where one side can discover information from the other side. This includes things like depositions, interrogatories, requests for admissions, requests for production. This is a very painful, costly process, and there are penalties if you don't cooperate. So it's something you need to be aware of. You don't really want to be there if you can avoid it. And as I said, post-trial motions, and it's can take a while. Civil cases, let me say, a lot of people are misled by TV shows that suggest that you file a case and a week later in court. No, that's not the way it works. Civil cases can take years. Criminal cases, they have a timeline in a criminal case to process a defendant. That's criminal defendant has a right, depending on the state law, to be tried under the U.S. Constitution, and state constitutions have a speedy trial provision. It's either 60 or 90 days, depending on whether the person is in jail or out, but that can be waived as well. Let's talk a little bit about jurisdiction. Important for you to understand that, because if you are in business and if you are engaged in selling goods online, you may accidentally subject yourself to a jurisdiction in a state that you personally never been into. So jurisdiction, very simply, this is a formula where you look at what is the subject matter of the dispute. Is it contracts? Is it a constitutional issue? Is it some statutory issue? You know, what is the subject of the dispute? All right, so you know what it is. Let's say it's a contract. Let's say it's a contract that is $50,000 contract. Okay, then the question is, does this court, and again, you look at the court systems, and I have those set forth on your course page with a diagram of the state and federal court systems. You look at, well, I have a dispute with another party over breach of contract, $50,000. What is the right court that has authority over this person? Well, you look at where the person resides, who you're suing. Normally you sue the person where they reside. However, if the contract was executed within the jurisdiction of the court, like let's say Thurston County Superior Court, that you could sue them here. Or if you're fighting over a particular thing, like let's say a piece of land or a car or something like that, and that thing is here, you can sue here based on the location of the thing. So jurisdiction, just to remind you, is the authority of a court, of that particular court, over the subject matter and either the person or the thing. Businesses subject themselves to the jurisdiction of a court if there's enough of a nexus. If they do business in the community, that might be enough to get them sucked into that court system. You'll see the discussion is in your book on the concept of long-arm jurisdiction. This is where the court reaches out by statute and hauls you back into that jurisdiction. So for example, you get into an auto accident here in Thurston County and you're from Montana and you think, well, I'll just go home and nobody will be the wiser. No, you're going to be hauled back into Thurston County because the accident happened here. Same thing with civil cases. If you sign a contract and it's executed here, you could be hauled in here. Look at your long-arm jurisdiction statutes. Those are a very powerful tool for businesses if you are involved in especially internet sales. Internet sales, you sell something and you have a very active website and you don't think ahead and you don't say on your website that the contracts will be deemed executed where you live. It might be deemed executed where the buyer is, and that might be very bad for you. So there are certain things that are exclusively left to state court systems, and certain things that are exclusively left to the federal system. And then there are things that are concurrent. For example, violations of your constitutional rights, whether it's, let's say, First Amendment free speech. Let's say you're a corporation, you donate money to a campaign, somebody sues you or whatever. Somebody violates your constitutional rights, you can go to state or federal court. So that's concurrent jurisdiction. It's surprising. A lot of people think, you mean I can go to state court over a federal, an issue that is in the federal constitution or federal statutes or federal regulations? Yes, you could. You could go to state court. What typically happens, though, is that the case will be removed from state court to federal court. So it gets complicated. Corporations, businesses have due process rights. You'll see this is discussed in the U.S. Constitution in the 5th and the 14th Amendment. It's in our state constitution as well. Just important to understand that there are two types of due process. One's called substantive, the other is called procedural. Substantive due process means that the statute as written, what we refer to in the legal profession as the black letter law, is clear. You understand what it does, what it prohibits. It's not vague. It's not overly broad. And if that's called substantive due process. Substance is clear enough that a reasonable person will know what is being prohibited or what's being regulated. Procedural is, it's a term that suggests, it's the process by which you go through the court system. As I described before with the civil case, it begins with a summons and complaint. Then you've got motions, you've got jury selection, you got a trial if you're going there. The trial can be with a jury or with just a judge. That's called a bench trial. And you've got appeals. That's the civil, essentially the civil system. There's a video on my website, or a link to a video all about that. The bottom line is it's a very costly experience, and business people aren't in business to sit in court all day and litigate cases. So businesses love alternate dispute resolution. And this means there's various types, but you're thinking arbitration, mediation, etc. Arbitration and mediation are the big ones. And why this is necessary for you to know, A smart business will put in their contract a arbitration clause. You see these with employment contracts. Your cell phone contract has an arbitration clause. What does this mean? This means that you waive your right to go to trial. By Constitution, you have a right, even in a civil case, to go to trial. But you can waive that. And when you sign a contract that says you're not going to sue the other party, that you're going to go to arbitration, that's a huge advantage for the party making the offer, because that will avoid the court, the costs, everything else. Plus, with a contract, the party that wrote that provision can define who the arbitrator is going to be, where it's going to be, if you lose, who's going to pay the costs, all kinds of things which make it extremely favorable for the party putting that in. So you'll see that in a lot of contracts, and from a pure business point of view, it's a very useful way to avoid the hellhole of the court system.